Dear students, good morning. In the previous lecture, it was lecture number, I think, number 3. We were talking about the differences between the contract of sale and the other contracts. We started with the differences between the contract of sale and the contract of gift. And we highlighted the most important issues in this regard, and we have said that the gift as contract, it contains the intention of donation. However, the contract of sale, it doesn't have it. And we highlighted the case when the difference between the contract of gift and contract of sale becomes a little bit hard. And this happens when the opposite um, is sum of money, I mean the price, and another thing. Or also we have said the differentiation between them becomes more difficult when the gift is granted to the donee with an opposite. This is what I meant. Sorry. So the previous case is not what I meant. This one is what I meant here. And after that, we have illustrated the contract of sale and the difference between it and the will as unilateral act. So the first big difference between them is that the sale is a contract. However, the will is not a contract. It is a unilateral act, as you have studied in the course, the sources of obligation. Now we will move to another contract, and we will differentiate between the contract of sale and the contract of lease. Well, what is the lease? The lease actually is a contract, so it's not a unilateral act. It is a contract like the sale. So this is one of the similarities between them. It's a general similarity between the lease and the contract of sale, is that both are contracts. So the lease is a contract by which the leaser, this is the first part, is obliged to empower or to enable whom? To enable the leasee. To enable them to what? From using the leased thing for a certain period of time. And that's all in an opposite, which is paid by the leasee to the leaser. هو عقد between two persons. The first one is the leaser or the مؤجر، يعني بإمكانه أو بموجبه يجب على المؤجر إنه يمكن to empower or to enable إنه يمكن الشخص اللي اسمه الليزي the second part of the contract with the المستأجر بإيش بمكنه إنه ينتفع بالشيء from using استعمال الشيء الانتفاع به from using the thing for a certain period of time مدة من الزمن. وطبعا هذا كله بيكون في مقابل بيعطي the lazy to the leaser. So we have two obligations here. So we can say that it is a double obligations contract. It's like the contract of sale. Both parties has obligations. The first obligation is on shoulder of the leaser, which is enabling the leasee from using the listing. However, we have another obligation on the shoulder of the leasee himself, which is giving the opposite, which is a price or sum of money to the leaser as an opposite for that using. So the main difference here between the contract of sale and the contract of lease is that in contract of sale, the first party, was the seller, is obliged to move the ownership. So the thing must be moved as it is. I mean, its ownership shall be moved from the seller to the buyer. The whole thing must be submitted to the buyer and it will be his ownership. However, in the contract of lease, the lease, it doesn't affect the matter of ownership. it only allows the lazy from using the leased thing. So it doesn't give him his ownership. However, it only allows him to use it or to get the benefit of that thing. So this is the main difference between the contract of sale and the contract of lease, is that one of them is contract regarding the ownership. It affects the ownership. However, the other conduct, it only affects the using or the benefit of that thing. Now we have a question here. It says contract, it's about the contracting on the outcomes or products of the thing, not the thing itself. It happens sometimes that a person may lease from me not the land that I have. However, he leases, for example, the fruits of my land. It's made that you heard about something called تضمين. فلان متضمن الشجرة اللي في أرض فلان. Then the question here is that if X, for example, concludes a contract with Y to take the fruits from Y's land, so I don't need your land. I'm not going to sell it or to buy it. Sorry, I need the fruits of your land, or to take the woods from your garden, or the minerals from your land. Okay, so in this case, is it a contract of sale regarding these stuffs, or is it a contract of lease regarding the land or the garden or whatsoever? To make it clear, I think I have to differentiate between two matters: the outcomes and the products. The outcomes are called in Arabic ثمار الشيء. However, the products are the منتجات الشيء. So the difference is that outcomes are ثمار, however, products are منتجات. Okay, this is in Arabic just to make the idea more and more clear. Now, in this case, I'm not talking about leasing the thing itself. I don't want to lease your land. I only want to take the fruits of your land, or for example to take the minerals which are existed in the deep or beneath the land of your land, or even I want to take the petrol which is existed, or the woods which are existed in your garden. So the question here, is it a contract of sale in this regard, or is it a contract of lease? Especially if I am contracting with you to give me the fruits of your land every month in an opposite, which is the price that I shall pay, as I don't know to tell you whether I am buyer or even leaser to you. I mean, paying you back. So the question here is that contract a sale or even a lease? So it's a so important question actually. Well, here the jurists of the civil law differentiate between the outcomes and the products of the thing. They say that the outcomes, or ثمار يعني, we can get them from the thing, like the fruits, for example, we can get them from the trees of the land in a regular way. And if we take them, they will not affect on the thing itself. Like when we take the fruits, is that affecting the trees? Like, do these fruits after they're taking, I mean, do they affect on the existence of the tree as a tree? Well, actually no, because the tree will remain. I only take the fruit of these trees. So these outcomes, they do not affect the gist of the thing itself. Like taking the fruits, they do not affect the thing which gives me the fruit, which is the tree. However, the products are things that are taken from a thing, like the woods that are taken from the garden, the petrol which are taken from the ground, the minerals which are taken also from beneath the ground. So these products are given to you irregularly, and also when I'm taking them, they affect the origin of the thing itself. So it will not be as it is. Every time I take products, it will become, it will start to vanish. So that's what I want to say here, is that there is difference between the outcomes and the products, is that the outcomes are given in a regular way and they do not affect the thing we are taking the outcome, its outcomes. However, products, they are given in irregular way, and if we take them, they will affect on the thing as it will start vanish. Okay, so that's why jurists of the civil law differentiate between these two matters, and according to this differentiation, the name of the contract will be different, whether it is a contract of sale or a contract of lease. Let's say that, for example, Baha, I told him that I need the fruits of your land. So we made a contract between us that I will take the fruits and Baha will keep his land. الآن هذا التعريف يتفق مع مين؟ يتفق مع الإيجار لسبب بسيط، إنه أنا باخذ الثمار، ماخذ المنفعة، وفي التزام على المستأجر انه يسلم العين المؤجرة للمؤجر كما هي. الآن أنا لما سلمته الأرض سلمته إياها كما هي، أنا بنظر للأوريجين للتريز زي ما هي. أنا ما أخذتش الشجر عشان أقول إنه عقد بيع إنه شريت شجرات، لا أنا أخذت الثمار. حتى هم بيسموه عقد استئجار ثمرة. لذلك إذا كان الشيء منصب على ال outcomes then it is a contract of lease, simply because the person who is the leaser, he keeps the land and he keeps the origins, I mean the thing itself. However, the leaser is taking only the benefit of that thing, which is the outcomes, in an opposite, which is the price. So it is said that the contract in cases of taking the outcomes of the thing is a contract of lease. It's not a contract of sale, especially if the process, I mean taking the fruits, happens regularly. So this is not the sale actually. The sale it happens one time. However, when I take them in a regular way in an opposite, which is the price, then it is actually a contract of lease. It's not a contract of sale. However, a product here, like when I have land, okay, and I have in the depth of this land, I have petrol, for example. So I contracted with a company which is going to take the petrol from this land or from my land. Then it is said that the contract here is a contract of sale, simply because the petrol which goes from the land to the sake or for the sake of that company will never come back to the land. I mean, when you take the petrol, it will like decrease the amount of the petrol which is found on my ground or in the depth of my ground. So this means that the thing that I'm dealing with is a product, simply because it affects the origin of the thing. Simply because when I'm taking products, the thing, I mean, which belongs to me, starts to decrease time after time. That's why in this case it is called a contract of sale, not a contract of lease. I want to share with you something from the internet. Well, here it is. Okay, here we have something. طلعوا في إشي بسموه منتجات الشيء اللي هي products that we were talking about، أو حاصلات الشيء. والحاصلات بقول لي هي ما ينتج عن الشيء بصفة غير دورية وغير منتظمة، وبتتناقص كلما استخدمناها إلى حد النفاذ. This applies to my example regarding the petrol or the woods that are taken from the garden. فإذا تعلق العقد بهذه الأشياء استقر الفقه على اعتباره بيعا وليس إيجارا، قياسا على أن عملية استخراج هذه الحاصلات يمس بجوهر الشيء the gist of thing، في حين أنه يجب على المستأجر أن يرد العين المؤجرة كما استلمها. لأنه لما باخذ البترول وبدي أرجع الأرض لصاحبها ما رجعتهاش تماما زي ما كانت، لأنه أنا كانت فيها بترول بطل فيه بترول. لأن لما أنت بتستأجر عين مؤجرة، تستأجر شقة، لازم عليك التزام كمستأجر تردها كما هي بنفس حالتها، مش ناقصة حيط يعني، مش ناقصة شغلات أساسية. Okay. So, for example, a person who owns a piece of land in which there is petrol, then he allows for a specialized company to dig into this land and to take the petrol. Then in this case, this is a contract of sale. It's not a contract of lease. However, in this case, we're dealing with the outcomes of the thing, أو الفروتس يعني ثمار الشيء, which are given by the thing regularly, okay, renewably بشكل متجدد. And if we deal with it, if we take them, it will not affect on the gist of the thing. Like for example the crops. فالعقد اللي بيقول لي هنا على ثمار الشيء قد يكون بيع وقد يكون إيجار بحسب ما يرجحه القاضي. الغالب بيكون إيجار، خصوصا إذا كان يعني الشيء يعني خلينا نقول إنه المستأجر هو اللي بيدفع قاعد على الثمرة، وهو اللي بيقوم بتلقيح الشجر. مثلا لو كانت مثلا على سبيل المثال بلح، فإذا كان هو اللي قاعد بيلقح الشجر وهو المعني بتنظيف الشجر، أو إذا كان هو اللي بحط السماد إلى آخره، then this is an indicator that the contract here is not a contract of sale, it is a contract of lease. However, if the person who cares about the trees and he puts the sediments and these things, however there is no interference from the other person who will take them, then in this case it's a contract of sale. So here it is mentioned انه اذا كان المقابل نقدي ومستحق بصفة دورية وفترات زمنية محددة ونفقات الزراعة على المستأجر، فبكون العقد ايجار، لانه بتشابه مع موضوع عقد الايجار، انه الاجرة بتكون بصفة دورية ومنتظمة وفي فترة زمنية محددة، وفي نفقات بتكون الحفاظ على الشيء المستأجر. نفقات الحفاظ على الشيء المستأجر زي ما انت تكون شقة وتحافظ عليها، على مين هذه الالتزامات؟ على الشخص المستأجر. فبتكون متماثلة في هذه الحالة مع هذه الفكرة المظللة هنا، فبالتالي بيكون عقد عبارة عن contract of lease. خصوصا انه الثمار اللي انا باخدها بتاثرش على جوهر الشيء، يعني انه الشخص في النهايه لما رجع لك الارض اللي هو متضمنها رجع لك اياها بالحاله اللي هي كانت عليها بشجرها يعني. However, if the opposite is a sum of money, which is a cumulative sum of money, or even the contract relates not all of the things or all of the fruits of your land, however it relates only some of these fruits, then the contract in this case is qualified as a contract of sale. Also, if the person who takes the responsibility for the expenditures of the agricultural works, then in this case, if he is the owner of the land, then the contract also is considered a sale. It's not a contract of lease. Okay, so this is what I wanted to show you. So the difference depends when I'm talking about the contracting that happens on the outcomes and the products of the thing, not the thing itself. We have to differentiate between the outcomes and the products. The outcomes are always considered contract of sale. The products, it may be the products are considered always as contract of sale. However, the outcomes, we have to differentiate between two cases that are mentioned in the examples that I have shown before. We have to say who takes responsibility for the expenditures. So these are some indicators which enables me to qualify the contract, whether it is a contract of sale or even a contract of lease. Okay, now let's we move to another kind of contracts, the contract of sale and the contract of mandate, or what is called the power of attorney. الوكالة يا جماعة والفرق بينها وبين عقد البيع. Well, the mandate is a contract by which the agent is obliged to do a legal deed for the sake of his mandator. So the agent هو الموكل، هو عفوا وكيل، والمانداتور هو الموكل. وخلينا نستخدم القلم هنا عشان نحدد الأشياء المهمة. So the mandate is a contract، هو عقد بمقتضاه the agent who the first party who is وكيل here, he is obliged to do a legal deed، لازم to accomplish or to implement a legal deed. بموجب هذا العقد الشخص الagent الوكيل عليه أن ينفذ التزام قانوني، عمل قانوني لمصلحة مين؟ لمصلحة الموكل اللي هو اسمه mandator. So we have two parties here. The first one is the agent, the second one is the mandator. The agent is obliged, according to this contract, to give or to accomplish or to do a legal deed. Look, not every kind of deeds. Like the material ones are outside the scope of the obligation of the agent. The agent obligations are always illegal ones. So, for example, when I make agency or a contract of mandate by which I demanded Baha to buy a land for my sake. Now, to buy a land, it means it is a contract of sale. It's a legal work. يعني أنا لما بدي أوكل بهاء يشتري لي قطعة أرض، هذا عقد الوكالة اللي أنا عملت له إياه هو عبارة عن عقد بموجبه بهاء ملتزم أن ينفذ عمل قانوني لي، تصرف قانوني، هو تصرف اللي اسمه البيع والشراء. So always the obligations of the agent are legal ones. We cannot imagine that these things are material one. ممنوع يكونوا مدني شغلات مادية، هي شغلات قانونية بيعملها لمصلحة المانديتور الموكل. According to this definition, the access of mandate is the legal act or deed. يعني جوهر العمل القائم عليه فكرة الوكالة هو العمل القانوني، التصرف القانوني. While the access of the contract of sale is to transfer the property from a person to another person. So this is the first difference between the contract of sale and the contract of mandate. The contract of mandate, the access of this contract is to implement a legal deed. That's it. However, in the contract of lease, the main obligation, the main access is the transference of the property from a person to another person in an opposite. Okay. The difference becomes a little bit difficult when a person gives his property to another, okay, but it is not clear whether that property is submitted to him in a way that transfers the ownership or it is submitted to him to act in favor of the original owner. For example, let's say for example a factory مصنع submits its goods and products to a commercial shop. يعني في عندي مصنع وسلم منتجاته اللي بيصنعها بايونير فور اكزامبل، سلمها لمين؟ اعتبروها دعايه لبايونير يعني. اوكي الان الفاكتوري submits its goods and products to the commercial shop، سلمها لمحل تجاري على اساس انه المحل التجاري يقوم بتوزيعها. اوكي but it is ambiguous، يعني في غموض حول if those products are submitted to that commercial shop، إذا كان هذه الأشياء سلمت لهذا commercial shop to act as the owner who will act in its favor, or it will act for the sake of the original owner, I mean the factory. يعني خلينا نحكيها بالعربي هيك. عندي مصنع بايونير سلم منتجاته لمحل تجاري كبير ضخم وقال له تصرف فيها، بس مش واضح من خلال العقد وألفاظه هل أتصرف فيها أنا تصرف المالك في ملكه، يعني أبيعها باسمي ولحسابي ككوميرشال شوب يعني، ولا أنا بس عملية وسيط بدي أروح أقوم ببيعها لاسم ولحساب المصنع. ما هو بتفرق عندي في التكييف للعقد، تفرق عنا في تكييف العقد. اوكي ففاكتور عشان مش عارف اذا كانت مبينه الشاشه قبل. A factory submits its goods and products to a commercial shop so as to distribute them, but it's ambiguous if those products are submitted to that commercial shop to act as the owner, or as if he is the owner who will act in his favor, or it will act in the sake of the original owner, I mean the factory, or the factor of pioneer as we mentioned previously. Now, anyway, the judge shall decide on this matter according to the surrounding circumstances. القاضي لما بيجي نوع من هذه المسائل بيميز بحسب طبيعة الظروف المحيطة بالتعاقد. So the contract is a sale، هيعتبر القاضي إنه العقد عبارة عن عقد بيع if the commercial shop sells them in his own favor at the price that he decides, pledging that it will pay the factory a certain sum of money for those products. القاضي هيعتبر انه العقد عقد بيع اذا كان الكوميرشال شوب باع الاشياء هذه باسمه وحسابه والسعر اللي بيحدده هو، طالما انه تعهد بانه يسلم للفاكتوري يعني مبلغ من الماني عن البضاعه اللي استلمها منه. Then this is a contract of sale. However, the judge will consider it a contract of mandate if the commercial shop is only selling such products for the sake of the factory, for in the name of the factory, and for certain sum of money اللي هي commission agent. لكن ممكن احيانا يجيك المصنع يسلمك البضاعه وانت كمتجر تقول انا حبيع لك اياها يا صاحب المصنع، حبيع لك اياها والمبلغ اللي بدي يجي حاعطيك اياه، بس انت بدك تعطيني عموله. يعني عمليا البيع مش باسمه ولحسابه ولا بالسعر اللي انا حددته، عمليا انا قاعد ببيع باسمك ولحسابك، بروج لك يعني وببيع منتجاتي باسمك على انه في النهايه ينوبني منك كوميشن العموله. وهذا نوع من انواع الكونتراكت اوف ايجنسي اللي هي الكونتراكت اوف مانديت او كونتراكت بنسميه كونتراكت اوف ايجنسي، بنسميه the commission agent الوكيل بالعموله. اوكي so this means that this matter which is here which represents a little bit a difficult matter, will not the answer depends on the circumstances which surrounded the contracting process. So the judge can decide whether it is a contract of sale or even a contract of mandate. To end, we have a contract of sale, a contract of deposit. عقد الوديعة يعني عقد الوديعة. Well, a contract of deposit is a contract by which a person is obliged to deliver something from another person, to keep it, and uh, and to resubmit it later to its owner. Well, it's like I contracted with Noor, for example. I told Noor Mater I need to conclude a contract of deposit with you. Now, according to this contract, I will submit to you something, and you have an obligation to keep it. And for طبعا ممكن يكون for a certain time. It's maybe that this contract of deposit is with an opposite or without an opposite. يعني ممكن يكون وديعة مأجورة أو بدون أجر. However, you have to resubmit it to me when I require it or when I demand it. Okay, so this is the contract of the deposit. So the main pillar is that the contract of deposit does not transfer the ownership as the depositee or the boner or depository here is obliged to resubmit the thing to its owner when required. However, the contract of sale doesn't transfer the ownership over something from a person to another. So the difference is that the contract of sale, it transfers the ownership from a person to another person. However, in the contract of the deposit, the ownership is still the person's ownership. He doesn't transfer it to the depository person or the depositee. So in this contract, there is no way to say that the ownership is transferred from person to another person. So this is the bottom line here in the differentiation between the contract of sale and the contract of deposit. To this end, I end my lecture, and I will see you, inshallah, in the coming lectures. Thank you for being patient. Thank you very much, and goodbye. Well, you have an exam, a quiz. It will cover only the first 3 lectures. It will be on the 18th of October at 10 a.m. Okay, and you have 20 minutes or 25 minutes to solve it. Thank you, and I wish you all the best in your lives. Goodbye.